Much for joining us on Middays with Gerard and Rito in the SuperTalk studios. Joining us now, Professor Christopher Greene. He's a law professor at the University of Mississippi. Hey, Professor, thanks for joining us today.
Thanks for having me again. These are exciting days.
You bet. So we wanted to have you on to talk about these cases that are coming before the Supreme Court, both in Texas and Mississippi, regarding various abortion rulings and laws. But kind of walk us through the chronology. Let's take Texas. They passed a law, and then it got upheld, I guess is a way to say it, by the Supreme Court, and now there's some challenges to that. So kind of walk us through the chronology. Tell us where we are today and what's going on there.
Well, there's a lot of different parts to it. So.
Yeah.
Last May, Texas passed a law, and basically the idea for the law is to channel challenges to it. So it prohibits abortions after 6 weeks of gestation and gets the state government out of the business of enforcing that. So it decides to take this regulation and put it entirely in the hands of the state judiciary. So individual people, not governmental officials, suing abortion providers. So it's trying to channel all of the abortion litigation into the state judicial system. So the way it works, we have this. Every state has its own judiciary. And those are subject to review by the United States Supreme Court under this section 1257. So I'm constantly telling my federal jurisdiction students, well, you got one kind of review, which is 1257, and then the other kind of review is where you go to a federal district court. Okay, so you go to your Northern District of Mississippi or your Southern District of Mississippi or various district courts in Texas. You go there and then take an appeal from there to the Fifth Circuit, which covers Texas, Louisiana, Mississippi, and go from there to the U.S. Supreme Court. So the issue in both of the cases the Supreme Court heard today is Texas allowed to channel all of the challenges to this abortion regulation into the state judiciary, subject only to review under 1257, or is either the federal government or the clinics allowed to somehow get this into federal court? And there's a whole bunch of moving parts about different ways you could try to get this into federal trial court. It obviously would be able to get into federal court at the U.S. Supreme Court on review of the state court judgments, but can you get into federal district court somehow? And there's a whole bunch of different theories, none of which are clearly great, and they've got all kinds of different problems that the justices were trying to weigh. I think they maybe have a couple more minutes left. But they're just nearing the end of fussing over all the different possible problems with these theories of how you can get into federal court, in a federal trial court.
Professor, the Wall Street Journal had an excellent op-ed, opinion piece over the weekend entitled "The Amendment That Remade America." And it really referred to the 14th Amendment. And it goes on to say that to a great extent, these cases really have at their core the 14th Amendment. Can you kind of comment on that?
Oh, that's absolutely right. So when we form a federal government, we design it in 1787 in Philadelphia, and then the states ratify it. There are a few, but not very many restrictions on what states can do. So there's just a very small handful of things that states can do. So almost, by far the most important provision in the Constitution that gets litigated is the 14th Amendment, because, for instance, if you complain that the state of Mississippi has violated your free speech rights, if you're complaining about Texas doing something, Louisiana, you are invoking the 14th Amendment. So the 14th Amendment is in the background of a vast, vast quantity of cases at the U.S. Supreme Court. The three biggest cases they've decided recently, or the last couple generations. So Brown, Roe, Obergefell, all of these are 14th Amendment cases. So an understanding of the original meaning of the 14th Amendment is absolutely essential. And I commend so the Journal had an interview with Randy Barnett, who's at Georgetown, and Evan Bernick, who's he's actually I've co-authored a couple of pieces with him myself.
Okay.
He's a new professor at Northern Illinois. It's an excellent book. It's wrong about a few things, but it's lighter than a lot of books about the 14th Amendment.
You.
I've got my own 14th Amendment book from a few years ago, and I'm actually hoping to write one of my own one of these years. But the Barnett and Bernick one will have to do for now.
Okay, so in the Texas case, who's the plaintiff, and what are they seeking?
Yeah, so we got two different. That question, what exactly do you want, was actually a surprisingly difficult question to answer. Justice Kagan was actually pressing it. So we got two lawsuits. One is by the clinics. It's a Whole Woman's Health. They've litigated a bunch of these cases before. They had a 2016 case at the U.S. Supreme Court. So we got the clinics, and then the second lawsuit is the federal government. So we've got. Okay, so those are the two sets of plaintiffs. And then the two sets of defendants, the clinics sued the clerks in the Texas judiciary and the judges. So it's Whole Woman's Health versus Jackson. Jackson is the name of one of the judges that they thought might hear one of these cases. The United States, they just sued Texas. The reason for this is if you're the federal government, you are allowed to sue the state itself in a way other people are not. So the federal government is allowed to sue the state of Texas. There's actually a case from 1892 also called United States versus Texas, which says that the federal government is not subject to the same sovereign immunity rules that private litigants are. Okay, so the federal government is allowed to mess with Texas in ways that private litigants can't. So there's questions about so in the United States versus Texas lawsuit from today, one big question is, well, what business is this to you? Why does the federal government have authority just to step in and say, hey, we're upset with unconstitutional stuff that might happen? Do they have a cause of action? So there's a bunch of questions about this 1895 case called In Re Debs, where the feds went after Eugene Debs, a labor organizer, and it's not it's hard to tell whether it's the highest prestige opinion in the world, but big questions about whether the federal government's going to just step in and just have a cause of action. There's just big questions about who exactly you're going to enjoin if these win. So suing the clerks or the judges, I think there was a number of justices that were really skeptical about that, and I think for good reason. Yeah. I think a theory that probably has more legs is suing the attorney general on the basis that all of these plaintiffs, so even though the attorney general himself doesn't have any enforcement authority, because all of these individual potential plaintiffs are sort of private attorneys general, they have the power to become private attorneys general. Therefore, because they have an analogous office, suing the attorney. So normally we sue an attorney general in order to prevent the DA from indicting us. If that's okay, maybe it's okay to sue the attorney general to prevent all these private attorney generals from coming after us. And then the argument, there's a bunch of detail like, well, but the attorney general doesn't have any authority here. And does he have a normal authority in supervising the DA? There were a bunch of interesting questions about just state constitutional law, like what can the attorney general do? And fascinating stuff. The issue of
complicated.
Suing the clerks has a big problem because you say, like, just taking a lawsuit, they're not doing anything wrong. and that might be perfectly lawful. So enjoining somebody for doing something that's perfectly lawful, and a number of the justices were skeptical about that. Extending Debs to cover this, they seemed skeptical about that. On the other hand, there was, I think, a very broad consensus among the justices that they just don't like Texas